There is a concept in my field called chain of title. It is the chronological series of recorded transfers of a piece of real property. Every deed, every mortgage, every lien, every correction instrument, going all the way back to the original grant from the government, if you can find it. A clean chain means every link connects. The grantor in each deed was the grantee in the one before. No gaps, no forgeries, no names that should not be there. A broken chain means someone, at some point, transferred something they did not have the right to transfer. The chain fails. The current owner, the person who thinks they own the house, owns nothing. Everything downstream of the break is void. I am a title attorney. For 14 years, my job has been to examine chains of title for defects. I am very good at it. I have killed seven-figure closings over a single unrecorded deed from 1983. I have found forged signatures on warranty deeds that passed 3 prior title companies without question. I once unwound a tax sale fraud that had cost an elderly widow her home, traced the chain back through 4 shell LLCs, and a notary who had been dead for 6 months at the time of signing. My firm sends me the files no one else can crack. My rate is $375 an hour. I earn every dollar of it. And I did not notice, for 6 years, that my own husband had built a broken chain across state lines, with my last name on the deed and a second family at the end of it. I am going to tell this story the way I write a title opinion, chronologically, with citations, without editorializing, because the facts, in the order I discovered them, are more damaging than any commentary I could add. The deed arrived on March 3rd. By the morning of March 4th, I had the marriage certificate. By the end of that week, I had filed the complaint with the Nevada Attorney General. By September, my husband was in custody. By the following March, he was convicted. I do not regret any of it. That is the part I want you to understand first, because everything that follows will sound like shock. It was not shock, it was execution. My firm handles high-value residential and commercial title work across 3 western states: California, Nevada, and Oregon. We get assignments through a standing partnership with a mid-sized escrow company. They send us anything complex, anything flagged, anything where the closing agent wants a lawyer's signature before they release the wire. Every Monday morning, Yolanda at the front desk brings me a stack of new files, usually 4 or 5, usually routine. On the Monday of March 3rd, there were 6 files. I remember because I counted them while the coffee finished brewing. The top one was a commercial refinance in Sacramento. The second was a residential sale in Carson City. The third was a quitclaim deed in Washoe County, Nevada. I opened the third one first because it was the thinnest, and I was tired. Inside the folder was a single-page quitclaim deed, notarized in Reno the previous Friday. A title commitment from a Nevada title company I had worked with before. A cover letter from our escrow partner requesting a standard chain of title review. A highlighted note, intrafamily transfer. Low risk. Signature verification requested. Intrafamily transfers are the lowest stakes work I do. Spouses moving property between each other for tax or estate reasons. Parents giving houses to adult children. They are quick jobs. I usually clear them in 20 minutes. I pulled out the deed. Grantor, John Blake Mercer. That is my husband's name. I sat still for a moment. I did not panic. That was not the kind of moment where panic would have been useful. I read further. Grantee, Margaret Lee Mercer. Mercer is my last name. Margaret is not my first name. My name is Catherine, but Mercer is mine, and I had taken it when I married John in 2009. The property was on Claridge Lane in Reno, Nevada. I did not own a house in Reno. Neither did John, as far as I knew. My first thought was, this is a mistake. Wrong John Mercer. There are probably hundreds of them. My second thought, and this is the thought that, in retrospect, contained everything, was, why would a stranger named Mercer be moving a deed that required my firm's sign-off on a California routing chain? I flipped to the notarization block. The notary had witnessed John Blake Mercer's signature on February 28th of that year, a Friday. The address listed for the grantor on the deed was not our house in San Francisco. It was a P.O. box in Reno. But the signature was his. I know my husband's signature. I have seen it on birthday cards, on mortgage documents, on the deed to our own house, on 14 years of tax returns we filed jointly. His signature has a specific quirk. The descender on the J in John crosses back over the baseline in a way most people's don't. It is idiosyncratic enough that, when I was newer in the profession, I used to use his signature as a practice example for my paralegals. This is what a stable idiotic signature looks like. Notice the reentry of the descender. The signature on the deed had that reentry. It was his. I put the deed down. I went to get coffee. When I came back, I opened the folder again, and I began, professionally, to do my job. The first thing I did was what I would have done with any chain of title review. I pulled up the public records for that address in Washoe County. The house had been purchased in May 2020 by John Blake Mercer and Margaret Lee Mercer, husband and wife, as joint tenants with right of survivorship. Purchase price $442,000, 30% down. Conventional mortgage in both names, neither of which was in default, according to the servicer records I could see from the recorder's index. I searched the Washoe County deed index for all instruments involving John Blake Mercer as a party. There were 4: the 2020 purchase deed, a deed of trust, the mortgage from the same day, a correction deed in 2021 that cleaned up a legal description error on the eastern boundary, and the new quitclaim, the one currently sitting on my desk, which transferred John's half-interest in the house entirely to Margaret Lee Mercer for nominal consideration of $10. He was quitclaiming himself off the property. A title attorney reading those 4 entries, without any context, would conclude one of 3 things. 1. A divorce settlement was underway and the husband was relinquishing his interest. 2. Estate planning, moving the asset into the wife's name for some tax or protective reason. 3. The husband was hiding the asset from someone, a creditor, a judgment, a different spouse. I already knew which one it was. I had known from the moment I saw the 2020 deed with both names on it. Because Margaret Lee Mercer was a name I had never heard, and I had been married to John Blake Mercer since 2009. But I did not let myself conclude anything yet. A chain of title review is a protocol. You do the protocol. I searched the Washoe County Marriage Index. There was a marriage certificate dated August 11, 2018. John Blake Mercer, age 41, married to Margaret Lee Henderson, age 34, witnessed at a chapel in Reno. I sat with that for a long time. Then I searched the Washoe County Birth Index. There was a birth certificate from November 2022, a girl named Claire Mercer. Parents listed, John Blake Mercer and Margaret Lee Mercer. I did not cry, I want you to know that. I wrote everything down in the notebook I keep for chain reviews, in my professional handwriting, with citations to the recording instrument numbers. I underlined the dates. Then I closed the notebook, walked to Yolanda's desk, and told her I was going to work the rest of the day from home. She asked if everything was okay. I told her everything was fine. I had just remembered a personal errand. I drove home slowly. John was at his office. He had a consulting practice in downtown San Francisco, where he was a strategy director who traveled frequently for client work. He traveled to Reno twice a month. I had always known this. He had clients there. One of them, he had told me, was a casino group, another was a real estate developer. He would leave Thursday evening, come back Sunday night. Sometimes he stayed through Monday. He had done this for as long as I could remember being precise about it, probably since 2017 or 2018. I used to tease him about Reno. I used to call it his second home. I had not known how literal I was being. At home, I went to my office, the one in the basement, where I keep my chain of title files and my Nevada practice materials. I locked the door. I spent the next 6 hours doing what no attorney should do with her own marriage. I ran a full background and asset trace on my own husband. I pulled every public record I could access legally. California Secretary of State Filings, Nevada Secretary of State Filings, financing statements, aircraft registrations, boat registrations, federal civil and bankruptcy court records, state court dockets in Alameda, San Francisco, Washoe, and Clark counties, every recorder's index in both states. I built a parallel life for John Mercer. It took 6 hours because he had been careful. He had an LLC in Nevada, Blue Trail Holdings, registered in 2017. I had never heard of it. It held 2 Nevada properties, the house on Claridge Lane and a rental condominium near the University of Nevada, Reno. He was the sole member. Margaret Lee Mercer was the registered agent. He had a Nevada driver's license, which I found through a reverse search on casino loyalty program records. You can, if you know how, cross-reference a name against players' club registrations in some jurisdictions. He had been a Gold Star member at 3 Reno casinos since 2018. The address on file was the Claridge Lane house. He had filed 4 years of Nevada state tax returns as a Nevada resident, which I could not see directly, but could infer from the absence of his California resident status on certain state-level records that I checked. He had been claiming California residency on our joint federal returns simultaneously. That was federal tax fraud. He had taken Margaret Lee Henderson to a hospital in Reno in 2022 as her husband, listed on the intake forms. I know this because of a minor traffic accident report, public record in Nevada, in which John was listed as the spouse emergency contact for Margaret Lee Mercer, who had been the driver. He had lived, by my count, 2 complete lives for 6 years. I closed the laptop at 9 in the evening. I did not know what I was going to do yet. I needed to think. I poured a glass of wine, exactly 1 glass, I remember that, and I sat in the kitchen, and I stared at the far wall, and I waited to feel whatever I was about to feel. What I felt, eventually, was not grief. It was professional offense. Let me explain what I mean. I have worked bigamy cases before. Not as a prosecutor, I am a transactional attorney, but as a title issue. When a bigamist dies intestate, or when the fraud comes to light during a refinance or an estate proceeding, the title question becomes, which spouse actually owned what and when? These cases are rare, but they exist, and I have consulted on 3 of them over my career. Every bigamist I have encountered in my professional work used the same mechanism. They picked a second jurisdiction far enough away that their first marriage was unlikely to surface in record searches. They used a slightly different version of their own name on the second marriage certificate, a middle name swap, an initial change, something just off enough to evade cross-referencing by a suspicious registrar. And they bought property, if they bought property at all, in the second spouse's name only, to avoid creating a paper trail that tied their 2 lives to the same asset. John had done none of those things. John had used his real name, John Blake Mercer, on both marriage certificates. The California one from 2009 and the Nevada one from 2018. Anyone running a basic name search against both states' marriage indexes could have found the overlap in 30 minutes. I had never run that search, because you do not run name searches on your own husband. And he had put the Reno house in both his name and Margaret Lee's name in 2020. Joint tenancy, on the public record, as John Blake Mercer and Margaret Lee Mercer. He had not hidden anything. He had counted on me not looking. But here is the part that was, professionally, unforgivable. Margaret Lee's legal last name before marrying John had been Henderson. She had become Margaret Lee Mercer because she married him, which means on any deed, any title instrument, any recorded document, her name was going to show up alongside his as Mercer and Mercer. And any title attorney running a name check, any attorney like me seeing Mercer and Mercer on a deed, would read it for 30 seconds, assume they were looking at routine spousal property, and move on. That is the most boring thing in chain of title work. Husband and wife, same last name, joint tenancy, you do not even look closely. You check the signatures, confirm the recordation, clear the file. He had known this. He had known exactly how my professional brain worked, because I had explained it to him at dinner parties for a decade. The stuff I look at closely, I had once said to him and to a couple we had for drinks, is unusual names, mismatched parties, recent transfers. A married couple moving property between themselves? I barely read those. That is the deepest cover you can have, legally, just be boring. He had listened. He had married a woman and given her my name, knowing that if our 2 worlds ever collided on a piece of paper, my own training would skip right over her. That is what broke me open, sitting at that kitchen table. Not the other woman, not the daughter, not even the 6 years. The fact that he had used me as camouflage. I spent the next 2 days preparing. I did not confront John. I did not answer his evening phone call on Monday, and when he got home on Tuesday night, I told him I had a nasty sinus infection and was sleeping in the guest room. He accepted this easily. He brought me soup. I watched him bring me soup and I thought, "You used my last name on another woman's wedding certificate." I smiled. I thanked him. I ate the soup. On Wednesday morning, I called a criminal defense attorney I knew from my bar association, Rachel O'Dwyer, and I asked her for a confidential consultation. Not for my husband, for me. I needed to understand what I was about to do legally. Rachel and I sat in a conference room downtown for 2 hours. Here is what she told me. Nevada is one of the states that still aggressively prosecutes bigamy. It is a Category D felony. Up to 4 years in prison, up to $5,000 in fines. In practice, first-time convictions often get probation unless there are aggravating factors. Aggravating factors included use of false identity documents. John had not used any. A pattern of fraud beyond the bigamy itself. John had, through the tax fraud and the property fraud through the LLC. And critically, the existence of children born into the second marriage under circumstances that amounted to civil deception of the second spouse. Margaret Lee Mercer had not known she was married to a bigamist. That made her a victim of fraud, not a co-conspirator, which meant she had standing, in Nevada, to pursue both a criminal referral and a civil action for fraudulent inducement of marriage. The civil action could attach his assets, including the joint assets he shared with me, to the extent they had been funded by income he had concealed from both of us during the period of the bigamous marriage. There was also a federal piece. Wire fraud. If John had sent any money from California into the Nevada household, which he clearly had for 6 years, and had done so while maintaining a fraudulent marital status, the movement of those funds across state lines in furtherance of the scheme could be charged federally. Rachel said she had seen the feds pick up bigamy cases for exactly this reason when the state prosecutor was slow. My California divorce would be the easiest part. With a Nevada conviction in place, or even just a Nevada marriage certificate on the record, my marriage to John would be voidable, not because I had done anything wrong, but because John's 2018 marriage invalidated any subsequent continuation of marital obligations on his side. The California court would treat it as a putative marriage on my end, which meant I would get all the protections of a divorcing spouse, but John would have no countervailing claims. He would owe me, heavily. Rachel asked me what I wanted to do. I told her. I wanted the Nevada Attorney General to prosecute, and I wanted Margaret Lee to have every piece of information I had, in the order I had discovered it, so that her civil claim would be airtight by the time she filed it. Rachel asked me how I planned to tell Margaret Lee. I told her I would figure it out. I drove to Reno on Thursday morning. I had Margaret Lee's home address. It was on the deed. I did not go there. I went to the elementary school where she taught. I had found her employer through her public social media. She was a second-grade teacher at a public school on the west side of Reno. I waited in the parking lot until the bell rang at 3:15. I watched her come out to her car with a tote bag and a travel mug. She was smaller than I had expected. Dark hair, glasses, a soft way of walking. She looked tired. Not unhappy, but tired. The way people look when they are raising a small child and working full-time. I got out of my car and walked up to her. I said, "Margaret Lee Mercer?" She turned. She smiled politely, the way teachers do when strangers approach them. I said, "My name is Catherine Mercer. I am John's first wife. He is still legally married to me. I think we should talk." She did not scream. She did not cry. She did not even drop the travel mug. She looked at me for about 4 seconds and then she said, "Follow me home. We should do this at my kitchen table. I need to pick up my daughter from daycare on the way." I followed her car through Reno. We picked up Claire, who was 3, in a pink jacket with John's nose. Margaret did not introduce me. She told Claire I was someone from work and put on a movie in the living room. Then Margaret and I sat at her kitchen table. The kitchen of a house that I now owned in some sense, because a quitclaim deed had just put it in her name alone, although she did not know that yet, and I showed her everything. I showed her my marriage certificate from 2009. I showed her our tax returns. I showed her the title to our house in San Francisco. I showed her photographs from my phone of us at our wedding, at vacations, at Christmas dinners. I showed her the deed he had just signed. I showed her the certificate of her own marriage from 2018. She listened in complete silence for 40 minutes. When I finished, she said, "I always thought his business travel was to a different woman. I thought I was the real one and he had a mistress. It never occurred to me he had another wife." I said, "I know, I am sorry." She said, "Don't be sorry to me. You are not the one who owes me an apology. Neither am I the one who owes you one. He owes both of us." I said, "Yes." We sat with that. Then she said, "Do you have a lawyer?" I said, "I talked to one Wednesday." She said, "Nevada AG, criminal and civil for fraudulent inducement." I said, "Yes." She nodded. "I want to be on the same filings as you. I want us to do this together. I do not want us to be opposing parties in anything. Is that something you are willing to do?" I looked at her. I said, "I came here to offer exactly that." She reached across the table. We did not hug, we did not cry together. We were two women who had been lied to by the same man, and we were, at that kitchen table, both of us making a professional decision about how to proceed. She shook my hand. Then she said, "I have one question, and I would like you to think about it before you answer." I said, "Okay." She said, "Claire is 3. She is going to grow up knowing her father went to prison for marrying her mother under false pretenses. She is going to need a lot of therapy. I cannot afford a lot of therapy. I am a second-grade teacher, and I am about to be a single mother. If there is a settlement out of any of this, and I have no idea if there will be, I would like some of it to go to Claire's care. Are you going to fight me on that, or are you going to help me make sure it happens?" I thought about it. Not for long, but I thought about it. I said, "I will write it into the settlement myself." She said, "Thank you." She walked me to the door. I drove back to San Francisco that night, and I did not go home. I went to a hotel. I wrote the referral to the Nevada Attorney General's office on my laptop at the hotel desk. I attached everything I had. I sent it at 2 in the morning. I slept 4 hours, and when I woke up, I had a voicemail from a deputy AG in Carson City who had been forwarded the referral and wanted to know if I could be in his office by the end of the week. I will not walk you through the prosecution in detail. The case, State of Nevada versus John Blake Mercer, is a matter of public record in the 2nd Judicial District Court of Washoe County. Margaret Lee and I attended every hearing. We sat together in the front row. We did not speak much during the proceedings themselves, but we went to dinner each night in Reno, at a quiet Italian place near her house. We did not talk about John. We talked about Claire. We talked about her classroom. I talked about chain of title. She talked about the parent who had called her about the school's field trip permission slips. We became, in some strange and permanent way, colleagues. John pleaded out eventually. His attorney had told him, correctly, that the evidence was overwhelming and that going to trial would add years to his sentence. He accepted a plea of bigamy plus 1 count of federal wire fraud, which the U.S. Attorney's Office had picked up as Rachel had predicted. He was sentenced to 4 to 6 years at High Desert State Prison. He would be eligible for parole in 3. The civil case was faster. Margaret and I filed jointly. We each had separate counsel, but our filings were coordinated, and John's attorney did not bother to contest. There was nothing to contest. We settled before discovery was complete. The settlement structure was Rachel's design. John's California assets, our joint house, his consulting practices equity, 2 retirement accounts were liquidated over the following year. After paying off the mortgage, legal fees, and tax liabilities, the net proceeds were divided into 3 portions. The first portion went to me. I received enough to buy a smaller house in San Francisco, in cash, and to rebuild my savings. I kept my firm, my career, my reputation, all of which survived the publicity surprisingly intact. My partners, to their credit, responded to the scandal by raising my billing rate. The second portion went to Margaret Lee. Her share reflected the 6 years of fraudulent marriage and the economic damage of the concealment. It was enough that she did not have to sell the Reno house and could stop worrying about making the mortgage payment for the rest of Claire's childhood. She did not quit teaching. She liked her job. She said she had worked too hard for her credential to walk away from a classroom. The third portion went into a trust for Claire. The trust paid for therapy, which Claire started at 4, with a child psychologist in Reno who specialized in family complex trauma, and is structured to pay for her education through graduate school if she wants one. I am a named trustee along with Margaret and Rachel. I attend the annual review meetings. I see Claire twice a year, usually at a birthday or a holiday that Margaret invites me to. Claire calls me Aunt Catherine. I am not her aunt. I am her father's first wife. But Margaret and I agreed early that Claire did not need that explained to her until she was old enough to ask. When she does ask, and she will, Margaret and I will answer together. 14 months after the quitclaim deed landed on my desk, I was in my office on a Thursday afternoon reviewing a file. It was another intrafamily transfer. Sacramento this time. Father to adult daughter setting up some estate planning routine. I had opened it 20 minutes before and was nearly done clearing it. The phone rang. It was Margaret. She never called during the workday. I picked up immediately. Everything okay? I said, fine, she said. Claire made you something. She wants me to send you a picture. Okay. A photo came through. A crayon drawing on lined notebook paper, 3 stick figures. A tall one with long hair, a medium one with glasses, and a small one in the middle holding both of their hands. Above the drawing in 3-year-old block letters, it said, MYMOMS. I looked at it for a long time. I texted back. Tell her I love it. I'm putting it on my office wall. Margaret sent back a thumbs up. I walked the printout to my office wall and I pinned it next to my Nevada bar license. Then I sat down at my desk, and I opened the Sacramento file again, and I finished the review. A chain of title only holds if you look at every link. I had missed one link in my own life for 6 years, and the cost of that missed link had been enormous, but the chain itself, the chain I had rebuilt out of what was left, was solid now. Every link examined, every name confirmed, every party accounted for. Outside my office window, the city was doing whatever the city does on a Thursday afternoon. On my desk, beside the Sacramento file, Yolanda had left a note. New file came in, Washoe County. I can route it to Daniels if you don't want to handle Nevada anymore. I looked at the note. I picked up a pen, wrote I'll handle it, and walked the note back to Yolanda's desk. Then I came back, sat down, and got to work.